was unceremoniously and undemocratically removed from the NDAA behind closed doors. I started calling for an up or down vote on this bill on May 24th because I feared that this would happen and that the NDAA would not do enough to address the epidemic of sexual violence and serious crimes in the U.S. military. Now that we've seen the text, it is clear that those fears were well-founded. Committee leadership has overridden the will of a filibuster-proof majority in the Senate and a majority of the House, who called for real reform that would have moved serious crimes to independent military prosecutors. Instead, committee leadership has codified the status quo, leaving commanders as the convening authority, even in sex crimes cases. That is the same system that everyone supposedly agreed is failing our service members. Unfortunately, this does not fix the issue of convening authority, which was the singular ask from the survivor community. The NDAA does not make the necessary changes to the military justice system. The change we must make, the change that survivors and veterans have asked for, is to remove all serious non-military crimes from the chain of command. Commanders are not lawyers or judges, and they don't have training or expertise necessary to make those complex legal decisions. And our service members have told us that they do not trust commanders to be unbiased or to deliver real justice in cases where they know the survivor or the accused. Though I've heard from my colleagues saying otherwise, the NDAA does not remove sex crimes or any other serious crimes from the chain of command. And I want to be clear about this because the American people and our service members deserve to know the truth. The NDAA keeps the commander as the convening authority. Every single court-martial will still begin with the words, "This court-martial was convened by order of the commander." It tells you everything you need to know. The NDAA also continues to offer commanders the ability to choose the members of the jury panel. I want to address this point specifically because I've heard a few misleading statements about jury selection. The NDAA allows the commander who is creating the court-martial to handpick other members of his command to be the jury pool from which the jury will be formed. Our bill, on the other hand, would put this responsibility in the hands of an independent attorney without a stake in the outcome. Unlike what some who lack an understanding of the UCMJ have said, under our bill, the independent prosecutor is not the same person as the independent convening authority. Those are two separate military attorneys. Don Christensen, president of Protect Our Defenders, said about the NDAA that, quote, "Because commanders retain convening authority and associated powers such as selecting jury court members, commanders still will wield significant influence over the court-martial proceeding. Such influence erodes the independence of the Special Victims Prosecutor and fails to address the concerns of the survivor community that conflicted commanders still have too much influence over the military justice process," end of quote. The command influence does not stop with jury selection. The NDAA also allows commanders to oversee preliminary inquiry. It retains commanders' ability to order depositions and to order warrants of attachment. It continues to allow commanders to grant immunity and to approve delays. It retains commanders' power to determine the incapacity of the accused and to select witnesses. It allows commanders to approve of findings and sentences and to order the reconsideration of ambiguous sentences. It also allows the commanders to grant clemency and to allow the accused to separate from the service instead of facing a court-martial, fully eluding the justice system. Anyone who looks at the system sees a system where the commander is still in charge, where their influence cannot be overlooked. There's no way for the prosecutors to be or to be seen to be independent under that system. There will be no improvement in trust or necessarily in the results. Today, just 1/3 of survivors of sexual assault in the military are willing to come out of the shadows to report their crime, showing a clear lack of trust in the current system. But 44% of survivors indicate that they would have been more likely to come forward if the prosecutor were in charge of the decision over whether to move forward with their case. The Military Justice Improvement and Increasing Prevention Act is the only provision that would empower impartial, independent prosecutors to make the vital decisions necessary for a criminal justice system shielded from systemic command influence, while allowing commanders to focus on what they do best: warfighting, training troops. I want to share the words of retired Navy Lieutenant Paula Coughlin, a survivor who brought the Tailhook Symposium scandal to light 30 years ago. She said, quote, "The efforts to gut reform are unacceptable to the survivor community and must be rejected. If this effort succeeds, it will be a slap in the face to those who have put it all on the line this past decade. Those survivors and the majority of my colleagues here in the Senate who support real reform deserve to have their voices heard." Mr. President, as if in legislative session, I ask unanimous consent that, at a time to be determined by the Majority Leader in consultation with the Republican Leader, the Senate Committee on Armed Services be discharged from further consideration of S-1520 and the Senate proceed to its consideration, that there be 2 hours of debate, equally divided in the usual form, and that upon the use or yielding back of such time, the Senate vote on the bill with no intervening action or debate.
Is there objection?
Madam President, reserving my right to object.
Senator from Rhode Island.
Thank you, Madam President. On military justice reform, I'm pleased that the NDAA that we will consider this week enacted sweeping and historic reforms that changes how sexual assault and other offenses are investigated and prosecuted in the armed forces. This bipartisan, bicameral compromise was achieved after tough negotiations with the House and also with the administration. And the House voted last week 363 to 70 to pass this bill with these reforms, an overwhelming endorsement of the work that we did. And I look forward to a similar strong vote in the Senate this week, sending these reforms to the President of the United States. As you know, there have been many proposals for improving how the military prosecutes sexual assault and other crimes, from senators, representatives, from the administration, and from other organizations, all of them with their unique merits. Bringing all this together was difficult and complicated, but I believe we have done so effectively. Our bill removes all meaningful prosecutorial authority from the military chain of command for the series of sexual assault offenses under the UCMJ, as well as for other offenses, including the wrongful distribution of images, domestic violence, stalking, retaliation, murder, manslaughter, kidnapping, and child pornography. Our bill creates a special trial counsel who are highly specialized, independent prosecutors who are outside the chain of command of the victims and the accused. They will have exclusive, binding, and final decision-making authority over whether to prosecute these offenders, not the commander. Under our bill, no commander will be able to overrule the binding decision of a special trial counsel to prosecute or not prosecute a case. Similarly, our bill ensures that the special trials counsel have the exclusive authority to withdraw or dismiss charges or specifications, removing that power from commanders. And finally, our bill will make a large number of necessary and conforming amendments to the UCMJ to effectuate this reform. And I'm sure there will be need for more of this during the 2-year implementation period. The bottom line is that the reforms contained in this bill represents a sea change in military justice. At the end of the day, this NDAA will enact the most sweeping reform to the UCMJ in decades. And that's why Protect Our Defenders, probably one of the most effective and vocal organizations founded on the premise of defending the rights of victims of sexual assault, said, and I quote, "The provisions included in this year's NDAA are the most transformative military justice reforms in our nation's history." Madam President, having made that statement, I would object.
Objection is heard.
Madam President,
Senator from New York.
I'd like to thank the chairman for his steadfast work on trying to find common ground here. But I disagree that all meaningful, quote, all meaningful prosecutorial, end of quote, actions have been taken away from the commander. These are the actions that still rest with the commander, and these are meaningful. Grant of clemency, highly meaningful. Grant sentencing witnesses, highly meaningful. Grant of immunity, highly meaningful. Order depositions, highly meaningful. Preliminary inquiry, highly meaningful. Separation authority, highly meaningful. These are things that are essential to the prosecution of any case. And so if the prosecutor doesn't have the right to do these things, it means the prosecutor has to go ask the commander, may I do these things? May I call this witness? May I have approval for a witness at sentencing? May I have approval for this preliminary inquiry? That request alone sends the signal to survivors and to service members that the chain of command is still in charge, that independent prosecutor, while the language of the bill sounds really good, they are independent and their decision is binding, wonderful. The perception of service members who understand the weight of convening authority, they know what the words convening authority mean, they know what the command ability and importance is, they may not receive these changes and these reforms in the way the chairman believes them to be seen. They may not see them as the most transformative reforms, end of quote, that have ever happened, because if they still perceive the chain of command in charge, it may not dent their willingness to report these crimes. They may not have now the ability to report and to have a belief that they can have faith in this system. And so my question to the chairman is, why didn't we take the extra step to do the one thing that we've been trying to do for 8 years, was to make these prosecutors, these independent, specialized prosecutors, which is what we have been fighting for 8 years, truly independent, and give them all the authority the convening authority had. The only change they would have had to make is the designation of convening authority would go from the commander to these new independent trained prosecutors. It's a simple change. It is a change we have begged for from the survivor community, from the veterans organizations, from Protect Our Defenders, the best and most effective vocal organization per the chairman. We have asked for that one change to be denied by this conference committee of 4 men in a closed room making the decision themselves. And for the chairman to get up and say that having such an overwhelming vote by the House of Representatives just shows how right they are, well, then why does 220 co-sponsors in the House mean nothing? Why does 66 sponsors in the Senate mean nothing? Why does the endorsement of every veterans group in America mean nothing? Why does the support of 29 attorneys general mean nothing? That's my question. And it's such a small thing. So yes, having an independent, trained military prosecutor outside the chain of command whose decision is binding sounds amazing. That's what we've been fighting for. Why not make it really independent? Why not take the convening authority and give it to the independent, trained military prosecutor? And sadly, the answer is the DOD do not want to change the status quo. They don't want to make these changes. And so what they're willing to do, Mr. Chairman, is they're willing to put a great label on it. They're willing to pretend they're doing the thing that we've asked them to do. They're willing to create the impression that they're doing the thing we asked them to do. But they know what convening authority means, and they retained it. And when asked, please take the convening authority, give it to the trained military prosecutor, please make a truly independent system like all these people are asking you to do, they said no. They said no over and over and over again. And unfortunately, our chairman did not want to disregard the views of the Department of Defense. And unfortunately, that is my job, to oversee, to provide oversight and accountability over the Department of Defense, over the executive branch. That is what the Constitution requires this chamber, this body, this Senate to do. We are not supposed to take our marching orders from the Department of Defense. We are not supposed to do what the generals ask us to do. We are supposed to look hard and fast at a problem that has plagued our service members who give their lives for this country. We are asked to solve the problem. And we have put forward legislation that has the blessing of 66 senators and 220 House members and every veterans organization. that we know of, and every single of the 29 attorneys general who have written a letter. We have this breadth of support, but it doesn't matter because it's not what the DOD wants to do. So yes, Mr. Chairman, having independent, trained military prosecutors who make decisions outside the chain of command that cannot be changed is definitely a step in the right direction, but it is not the independent review that we asked for, because without convening authority, the perception of service members, of survivors, of the men and women this justice system is designed to protect will be that all these rights and privileges sit with the commander, and that these are rights and privileges that have value, that have, quote, meaningful prosecutorial value. They're not meaningless. And if they were so meaningless, then you would have given it to the independent prosecutors. That is why, Mr. Chairman, I will keep fighting on behalf of survivors. It's why we do not just say we're excited and we go home. It's why we haven't decided this is the moment to celebrate, because for us it's not. Because I worry that that percentage of sexual assault, rapes, and unwanted sexual contact, the 20,000 they're estimated every year, that the percentage of those that will be willing to come forward will not go up, that the rate of cases will not go down, and that the rate of cases that end in conviction will not go up. So that is my concern. It is why I stand here gravely concerned and very dismayed and very disappointed that we did not take this moment in time to do the right thing on behalf of our service members, to have a military justice system that is worthy of their sacrifice. Madam President, I yield the floor.